number of councillors and a very large number of residents, funded by social fundraising, and quite a number of councillors have been involved in it, regarding an application over at Westridge on the other side of the island. Peter and I and others have been following that intimately all the way through the process. Peter and I attended the hearings on Mountry Hill over at Southampton, and I went up to London for the Court of Appeal hearings, which were quite intense, in London. They were chosen because of the national implications of some of the matters that were being discussed, not only to be heard at the Court of Appeal, but to be televised by them. So there were quite a number of people watching that real time over the 2 days, while the rest of us were feverishly trying to support the solicitors and barristers in their arguments. That was successful at the Court of Appeal. There's been some attempt, I know, to minimise the view that was expressed there. But the bottom line is that the issue of process that was brought up not only was heard by them, but resulted in the planning application being quashed. That's the secondary issue that's just come out the last couple of weeks. Now, why was it quashed? It was quashed because there is a legal process for the council to publish a draft version of the agreement, called a 106 agreement, that they are proposing to agree between the planning authority and the developer, for the developer to make a contribution to local infrastructure and other matters. And the Isle of Wight Council didn't publish that 106 agreement, and in fact there have been many occasions where 106 agreements have been sought and not provided, and I haven't been able to find a single instance where a 106 agreement has been published in a draft form, either for the public to comment on at that late stage, or for the planning committee to be informed on at that late stage. That is clearly a violation of law, and therefore the process was improper. There is, at the moment, a freedom of information request. A number, I'll correct that, I believe, but at least one freedom of information request into the council, seeking to identify, I believe going back 8 years, which other planning decisions have been made by the Isle of Wight Council, this is the matter you were discussing there, where a similar error in law has been made. Because the assumption would be that if the same error had been made, i.e. failure to publish a 106 agreement for public comment, or for the planning committee to be fully informed before a planning meeting, that the similar result should follow. I mean, it's a natural principle. And if it turns out that 106 agreements have never been published, then all would be subject to interpretation, possibly by the same error in law, including the matters which you've been discussing. So it may not be the case that individually they have to be taken under a judicial review process, in that, you know, what's good for the goose is good for the gander, I think is the expression, but the legal precedent shows that if a decision is made on a very clear legal matter, and the same process failure occurs on other planning applications, that the same result should follow. What the implications of that would be, I don't know. And that is a national possibility, not only an Isle of Wight issue. So that's where we're at with it. I think a number of us are very much looking forward to seeing that FOI, because it not only asks how many have been done, but what it says is, for all those where correct legal process has not been followed, please list them. Now, if that is something which occurs to everything going back 7 or 8 years, it could be a very long list. It could include quite a number of planning applications which have since been built, delivered, and we've got people living in them, and there may be implications for that too. So I don't think we should jump to any conclusions about where this is going. I think this is very much new news. It's occurring real time, and the implications of it could be quite substantial. So I'll leave it at that. Thank you.
I think you raised very important points about
a draft version of the 106 agreement for Berks Close before it was agreed? Hands up, please. Doesn't look good, does it?
Well, was it available? Can you see if it was online at the time?
I think, and it's a while ago now, but I think it came, if you look on the planning portal, I think the decision notice is dated the same date as the 106. And the 106 has to be published prior to the decision notice. And I need to double check that because it's a while ago now. If that's correct, then by my understanding is by the Western ruling, then Berks Close decision notice should be quashed. And that means there is no planning consent. But I don't want to get you all excited because I might go home and find out that I'm wrongly remembering it and remembering another application. But I think that sticks in my mind because it was such a major application. But I will double check.
Logic would suggest it should be published before the decision is made, not just the notice.
Well,
because you would have thought the decision was made in the light of.
So the Lord did bring that up at the deal, and his if I'm correctly paraphrasing, was it published 7 days before the planning meeting, so that the public had an opportunity to comment on it, and that the planning committee members could read those comments that were coming back from the public, and that the planning committee members had time to read the draft agreement and themselves comment on it, or at least bring it up in the meeting.
yeah.
So the 7-day issue was raised very clearly. There have been requests for 106 agreements, which draft ones and final ones even, which have not been made available. So I think this is a major issue, and as I said earlier, it doesn't just apply to our local authority. I think this has national ramifications.
Yeah.
I've already downloaded and saved the rather extensive video from those 2 days of hearings, because I think that can easily be something that's referenced in cases to follow as effectively defining case law for the interpretation of it.
Going back to the development stream